of TCC Judgment 113 Champagne Act 2024, the constitutionality of death penalty case. High notes. Mandatory death penalty for homicide during extortionate kidnapping without consideration of circumstances is unconstitutional. Death penalty for homicide, homicide during rape and aggravated rape, homicide during robbery and homicide during extortionate kidnapping under the criminal code, hereinafter the code, is constitutional if applied in the most serious cases and conform with the strictest requirements of due process in criminal procedures. Specific procedural safeguards are required for the offenses above. Mandatory counsel during criminal investigation and on final appeal. Mandatory oral arguments on final appeal. And a unanimous decision by collegial panel of professional judges for death penalty sentences. The Taiwan Constitutional Court (TCC) specifies several extra procedural safeguards for defendants with mental conditions, disorders, or deficiencies. In the cases in question, the death penalty will not be imposed if an individual's mental condition significantly reduces their ability to make judgment at the time of the offense or render them incompetent to stand trial. Inmates shall not be executed if their mental condition impedes their competency for execution. Background note. In Taiwan, about 50 provisions in several separate criminal statute law stipulate capital punishment as the maximum punishment. Under the code, the maximum punishment for certain crimes, homicide during robbery, rape and homicide during extortionate kidnapping, is the death penalty. The TCC has formally upheld the constitutionality of the death penalty, applicable under special criminal law provision in JY Interpretation number 194-263-476, years after the announcement of the JY Interpretation number 476. The question of whether the death penalty is constitutional, and if so, what are the substantive and procedural requirements, arises again upon the petition filed by the petitioner in this case. Insofar as there are 37 death row inmates in Taiwan, all of them are petitioners in this case. The petitioners were found guilty of at least one of the following 4 crimes. Homicide, offense of Article 271, Paragraph 1 of the Code. Homicide during rape and aggravated rape, offense under the first clause of Article 226-1 of the Code. Homicide during a robbery, offense of Article 332, Paragraph 1 of the Code. And the homicide during kidnapping for ransom, offense of Article 348, Paragraph 1 of the Code, both the current and April 21, 1999 version. The petitioners were all found guilty and sentenced to death in their respective final court decisions between 2000 and 2020. After exhausting ordinary judicial remedies, the petitioners filed for constitutional reviews respectively. They argue mainly that the punishment of the death penalty and the mandatory death penalty applicable under the said criminal provisions that they were found guilty of was unconstitutional for violating their right to life. The criminal procedures they underwent violated the due process of the law, as such procedure had left them without effective assistance of counsel and the proper oral argument during their last appeal. Article 19, Paragraph 2 of the Code was unconstitutional insofar as it did not prohibit death penalty from being sentenced or executed on those defendants with mental disorders. The petitioners' cases were consolidated and argued April 23, 2024. Justice Zhong Jun Cai, Justice Cai Qian Cai, Justice Peng Xian Yu recused themselves and took no part in the deliberation or argument or the decision of the case. Summary of the judgment holding. Article 271, Paragraph 1 of the Code, hereinafter Provision 1 stipulates a person who takes the life of another shall be sentenced to death or life imprisonment or imprisonment for not less than 10 years. The first clause of Article 226-1 of the Code, hereinafter the Provision 2, stipulates a person who commits the offense specified in Article 221, 222, and intentionally kill the victim shall be sentenced to death or life imprisonment. Article 332, Paragraph 1 of the Code, hereinafter Provision 3, stipulates a person who commits robbery and intentionally kills another shall be sentenced to death or life imprisonment. Article 348, Paragraph 1 of the Code, hereinafter the Provision 4, stipulates a person who commits an offense specified in Paragraph 1 of the preceding article and intentionally kills his victim shall be sentenced to death or life imprisonment. Intentional homicide under said provision is the most serious offense against a person's right to life, which may be punished most severely to the extent of the death penalty. However, the death penalty must be applied to the cases with the most serious circumstances and conform to the strictest requirement of the process. Within this scope, the said provisions do not violate the right to life enshrined in the Constitution. The April 2, 1999 version of Article 348, Paragraph 1 of the Code, hereinafter Provision 5, which stipulates a person who commits an offense specified in Paragraph 1 of the preceding article and intentionally kills the victim shall be sentenced to death, violated the constitutional principle of non penal sine culpa, because it fails to distinguish whether the circumstances invoking the mandatory death penalty are the gravest. Within this scope, the provision does not conform to the right to life under the Constitution. A person suspected of committing the offense in Part 1 of the holding, Provision 1 to 4 cases shall be represented by a legal counsel when questioned and examined. The Code of Criminal Procedure, hereinafter COCP, is unconstitutional insofar as it lacks the relevant provision requiring so. It contravenes the constitutional protection of the right to life, the defendant's right of defense, and the due process of law. Authority concerned shall amend relevant provisions following this judgment within a 2-year grace period. If the amendment is past due, investigation shall be conducted in the manner required by the judgment. However, the concluded investigation remains valid and unaffected. Mandatory counsel shall apply to final appeals for provisions 1 to 4 cases. Such application is not required in Article 388 of COCP, hereinafter Provision 6, which stipulates that Article 31 does not apply to a trial of a certain instance. Within this scope, the provisions contravenes the constitutional protection of the right to life, the defendant's right of defense, and the due process of law. The said provision shall cease to be effective upon the announcement of this judgment. Authority concerned shall amend relevant provisions following this judgment within a 2-year grace period. Courts of final appeals, third instance, shall immediately apply mandatory counsel when hearing Provision 1 to 4 cases. Regarding Provisions 1 to 4 cases, oral argument shall be required for the Court of Final Appeal to hand down a death penalty or to uphold lower court's death penalty decision. Such requirement is not provided in Article 389, Paragraph 1 of the COCP. Hereinafter Provision 7, which stipulates the court of third instance may be tried without oral argument, provided that the court may order argument if necessary. Within this scope, the provisions contravenes the constitutional protection of the right to life, the defendant's right of the defense, and the due process of law. Authority concerned shall amend relevant provisions following this judgment within a 2-year period. Courts of final appeal shall try with oral argument when hearing the cases in question immediately. The death penalty must be imposed only by unanimous decision from a collegial panel of professional judges. The Court Organization Act does not specify so for Provision 1 to 4 cases, which contravenes the constitutional protection of the people's right to life and the due process of law. Authority concerned shall amend relevant provisions following this judgment within a 2-year grace period. The courts at all levels shall apply such requirements immediately. However, the effectiveness of a previous decision made before the judgment shall not be affected. To conform to the constitutional principle of non penal sine culpa, this penalty must not be imposed if the defendant at the time of offense was in the circumstances described in Article 19, Paragraph 2 of the COCP, hereinafter Provision 8, which is a significant decrease in the ability to perceive the illegality of an act or to act accordingly due to mental impairment. The authority concerned shall amend relevant provisions within a 2-year grace period. Before the amendment, the death penalty shall not be rendered in cases with such condition. To conform with the constitutional guarantee of the right to life, the defendant's right of defense, and the due process of law, the courts shall not sentence the defendants of the provision 124 cases to death if they had mental conditions that clearly diminish their ability to defend themselves in court. The authority concerned shall amend relevant provision within a 2-year grace period. Before the amendment, the death penalty shall not be rendered in cases with such conditions. 9. The sentence to death in provision 124 cases shall not be executed if they have mental conditions that impede their competency for execution. The COCP and the Prison Act violate the constitutional guarantee of the right to life and the due process of law, insofar as it lacked provisions prohibiting such inmates from being executed. The authority concerned shall amend relevant provision as appropriate within a 2-year grace period. Before the amendment, the death penalty shall not be rendered in cases with such condition. 10. All petitioners sentenced to death may file for extraordinary appeal with the prosecutor general if their cases were not the most serious. The prosecutor general may also lodge an extraordinary appeal as official for such cases. 11. Petitioner number 36, 37 may file an extraordinary appeal with the prosecutor general for their final court decision. Supreme Court Criminal Judgment 89, 台项 2196. The prosecutor general may also lodge an extraordinary appeal as official. After revoking their decision, the Supreme Court shall apply provision 4 in accordance with this judgment. All petitioners may file for extraordinary appeal with the prosecutor general for the part in which Article 3AA and 3A9, paragraph 1 of the COCP, which were applied in their final court decisions, violated the Part 4 or 5 of the holding. The prosecutor general may also lodge an extraordinary appeal as official. The petitioner may not lodge such an appeal if their final court decision had undergone oral argument and had been assisted by defense counsel. Petitioners may file an extraordinary appeal with the prosecutor general if the deliberation under the Court Organization Act resulting in their sentence did not comply with the Part 6 of the holding, unless there is a proof that their decision were rendered unanimously by a collegial panel. The petitioners may file for extraordinary with the prosecutor general, or the prosecutor general may file one as official. The legal provisions apply in the final court decision of petitioner number 12, 13, and 14. Supreme Court Criminal Judgment 99, 台项 5659, 100, 台项 6514, and 102, 台项 2392 did not conform with the Part 8 of the holding. They shall not be executed before the concerned authorities amend the relevant laws as appropriate. After the amendment, the petitioner may file an extraordinary appeal with the prosecutor general, or the prosecutor general may file one as official. When the Supreme Court revokes those original decisions on extraordinary appeals, detention in the remitted cases shall be handled by respective competent courts.